No, Mr. Fitzgerald.
Yes.
You'd almost finished.
Yes, my lord. I was dealing with. I dealt with how the judge reasoned it, and now I'm turning to the Court of Appeal, and I've dealt with what the Court of Appeal said about the third appellant, and now I want to invite the board to look at how they dealt with the first appellant, Mr. Stubbs, in relation to the Higgs point, and that's at page 3391, paragraph 167. So if I can just go there. So at paragraph 167, the court said, in our view, the provision of section 120 and the ability to introduce a prejudicial and disputed report without giving an accused the ability to cross-examine the maker of the report is a discretion that must be carefully exercised. And that was echoed by the board in the case of Bain recently. In this particular case, there is nothing in the record which explains why Mr. Higgs could not give his evidence by video conference, thus obviating the need to travel back to Nassau. So that deals with the point that there was all reasonable steps had not been taken to secure his attendance. But then in relation to whether an injustice was caused, they deal with that at 169 to 171. However, as pointed out in the trial judge's ruling, counsel for the first appellant at the trial gave no reason as to why he wanted Mr. Higgs to give evidence. I agree with the trial judge that he ought to have given some explanation as to why he thought that it was in the interests of justice and a fair trial for the first appellant that Mr. Higgs be called to give oral evidence. The trial judge was correct when he said it's not just a simple matter of saying, I want him for cross-examination. They have to justify it. I was just pausing there for a moment. What the judge actually did was to say it was in the interests of justice that Mr. Higgs be called. So he would have been called and available for cross-examination by all of the defendants. For the first appellant, this is particularly so because it was his defence as contained in a statement to the police that the gun was not his and he did not place it under the car. The ballistics report as to the connection between the gun and the bullets was ex facie immaterial to his defence. We respectfully submit that that just misunderstands the nature of the right that the first appellant was asserting. He wanted to test whether the damning evidence that the gun allegedly linked to him was also linked to the casings found at the scene of the murder was reliable. And indeed, he'd identified in the second trial questions as to continuity that he wanted to test. So we say that immaterial to his defence suggests that there's a positive duty on the defence to put forward a defence rather than a right, an inalienable right, to test the prosecution case both on continuity and the soundness of the prosecution's evidence. He then goes on, the learned judge, I accept that the burden is upon the prosecution to prove its case against the first appellant, and not for the accused to prove his defence, and the accused has a fundamental right to a fair trial. However, in my judgment, the first appellant cannot be heard on appeal to complain about the admission of Mr. Higgs's report in circumstances where he refused to explain to the trial judge the reason why he wanted to require Mr. Higgs to testify. Well, we say, and we've dealt with this in the reply, it's a sufficient reason to say, I want to test the reliability of this expert's evidence. That is, you don't have to go any further than that. You don't have to say, these are the questions I want to put to him and give, as it were, a schedule of questions. That is contrary to principle and contrary to the presumption of innocence. It must be recalled, and then this is just simply wrong, that in the first two trials, Mr. Higgs's report was admitted under section 120 without objection from the first appellant. In fact, and we've dealt with this in the case at 6.8, that in fact the position was that the defendant did object at the trial, in the second trial, but his objection was overruled. My lords, can I just make sure I've given you the right reference to the objection? It's at 6.8, I think, of the case that we deal with this. Let me just make sure I've given you the correct reference. No. My lords, I will track it down, but there's no doubt that the point was taken that there was an objection to it, and indeed I think this is dealt with in our reply. Yes, it may be our reply where you can find it. Yes, 6.8 of our reply. I'm so sorry. 6.8 of our reply at 5500, where we actually deal with this point. So the Court of Appeal, with great respect, got that just completely wrong.
Right. Well, but just I'm not so sure that that's of primary importance, but just so that I understand your submission, let's take the situation where a witness cannot be obtained and the prosecution seeks to introduce his statement in evidence. You're not saying, are you, that if the defense says, well, we want to cross-examine him without specifying on what basis they want to cross-examine him, that the judge doesn't have it within his discretion to say, well, I'm sorry, I'm going to admit his evidence. I assume you would accept that.
Well, my lord, there is a discretion under section 66 of the Bahamas Evidence Act to admit documentary evidence where a series of preconditions are met, one of which is that the evidence is unavailable. The witness is unavailable. And I accept that under that section, it's possible that if one could establish that the person was simply unavailable, the judge would have a different discretion to exercise.
Yeah. Well, let's take the situation that obtains here,
yes,
where it wasn't established that the witness was unavailable, but the judge decided that this witness was either very important or possibly even pivotal. Do you say that in the absence of any articulated reason on the part of the defense for requiring the attendance of the witness, or for saying why challenge to his evidence was required, that the judge is wholly divested of discretion as to whether to admit the evidence?
My lord, I say if he's an important witness, I'm sorry if I'm not answering the question, but if he's, can I just get the proposition? If he's an important witness and he is available, and the defence say we want to test his evidence, he should be called. If he's an important witness and he's not available, then I accept that there would be a discretion.
Yeah. Well, if he's an important witness and it hasn't been established that he's not available, does the judge have any discretion, whatever, in the absence of any specified reason that the defense requires his attendance? Is the judge bereft of any discretion to admit the evidence?
My lord, if the defense had no, as long as the defense say, I want to test his evidence, I say that the judge doesn't have a discretion. If he's an important witness and he is available, I say that then.
No, I'm sorry, I qualified it by saying that it hasn't been established that he's not available, which I think is the situation here, isn't it?
Yes, it has. Yes, it wasn't established that he was not available. Yes.
Yeah.
I mean, the judge said, yes. I say that the judge, yes, I say there's no discretion. That once the defence have said, we wish to test his evidence, we don't accept it, we want to test it, and he's an important witness against, then I say that there is a right to test it. And that the discretion that might arise if it was shown that the person was, as it were, completely unavailable is a different one.
Right.
My lord, that's how I respectfully put it. My lord, and then, so I think I've dealt with, so, and then paragraph 172 is really, well, there was enough evidence anyway. Well, of course, there wouldn't be if Scott and Campbell are subject to the defects that we've sought to identify already. My lords, so that's our case. My lords, just going on from there, At 8.14, we submit that, so that's at 3748 of the case, we submit that it was potent evidence, and you can see that from the way the trial judge directed the jury, where he says the prosecution places particular emphasis on the objective evidence from Terence Higgs, and then sets it out. So clearly, it was regarded by the judge rightly as important evidence against Mr. Stubbs. And then obviously it couldn't be challenged without being questioned. No details were contained in the report as to what tests Higgs had carried out. There were no reasons given for why his comparisons showed a match between the casings and the firearm, no drawings or photographs, none of the control bullets or the casings had been preserved, neither had the defendants ever been given the opportunity of seeing or examining them, and no accompanying notes. And there were questions that established that asked by the defence counsel of the, as it were, substitute witness who was put forward. Therefore, there was no means by which to evaluate the processes that Higgs had undertaken or the quality of his analysis. And so we say that he was deprived of a real opportunity to cross-examine in a situation where it was important. And of course, you don't know until you've cross-examined whether the evidence does turn out to be faulty or unreliable. You need to exercise the right in order to test whether, for example, continuity is established, for example, whether reliability of the conclusions is established. My lords, we've dealt with section 120 and its constitutionality at some length from 8.16 to 8.36. Can I just summarize our point basically in this way? We say that if you interpret section 120 subsection 2 in such a way that it will be in the interests of justice to afford the right to cross-examine in a situation where there's important evidence and the defence wish to challenge that evidence, and there's no countervailing evidence of simple unavailability, then it wouldn't be unconstitutional. But if, as the Court of Appeal and the trial judge at one stage appear to have done, you say you've got to identify some special reason, and in the absence of some special reason, you simply can't, the evidence will go in unchallenged by cross-examination, then we say that that would violate a constitutional right. Now, we've analysed the position of various international courts, the US Supreme Court from 8.25 onwards at page 3751. And there's no doubt that the US Supreme Court, in the two cases that we've set out, Melendez-Diaz and Massachusetts, and Bull-Cumming, which are at 3752, say that you cannot, in a situation like this, provide a surrogate analyst to put forward someone else's report and to answer questions on it. They say that the evidence, if it's functionally equivalent to live in court testimony, doing precisely what a witness does on direct examination, and the maker is available, then the report is inadmissible hearsay. That's at 8.26, a quote from Melendez-Diaz. And Bull-Cumming is interesting. It's the same type of situation where there was an attempt to use a surrogate analyst rather than the person who'd conducted the tests. And the US Supreme Court was in no doubt that violated the Sixth Amendment. Now, I accept, and we've dealt with the European case law and Horncastle from 8.30 onwards, that there is no direct equivalence between the Sixth Amendment right and the right to confront witnesses under the European Convention, Article 6.3d. However, it is clear that there has to be a carefully circumscribed right to put in evidence without the opportunity to cross-examine. And there has to be a good reason on the facts of the case for adducing hearsay evidence. I do apologise. At 8.31 and again at 8.33, it's the Court of Appeal that who's ruling, but I'm summarising. So it should, if you could cross out Supreme Court and put in the Court of Appeal. Lord Phillips in the Supreme Court didn't say anything different at paragraph 38, but this is that they summarise the effect of the ECHR jurisprudence at 8.31 is that there has to be a good reason on the facts of the case for adducing hearsay evidence, and that's at 4621. And again, at 8.33, it should be the Court of Appeal, the full court's judgment. Lord Thomas giving that judgment at page 4627, the quotation, there must be a legitimate justification for the admission of the absent witness's statement. It must be established and appropriate counterbalancing measures must be taken. So that principle, which is in fact a similar principle that we would say would be exercised under section 66 of the Bahamas Evidence Act, which is the alternative route that was explored in this case. We rely also on Davis, which was cited by the Court of Appeal in this case, where Lord Carswell said, and it's at page 4447 of the thing, we've quoted it, that there must be a clear case of countervailing necessity to allow the admission of any inroad to the right to cross-examine witnesses. So here, where there is no clear case of countervailing necessity, we would say there should be no inroad. So we say it's the wrong approach to say you justify why you should exercise the right to test the reliability of this witness. My lords, I'm not going to go back to it in detail, but the US Supreme Court stresses the importance of the right to be able to test a forensic analyst's report. As it were, you don't find out whether there are flaws in it until you've exercised that right. And certainly the experience of the last decades has proved that right time and time again, where forensic analysts have been proven to be overstating their case or the conclusions. And if we look then at 8.37, we make the complaint that the Court of Appeal didn't address the constitutionality argument, but the way we put it to the Court of Appeal was, if you interpret section 120 subsection 2 in the way that we respectfully submit it should be interpreted, then there is no unconstitutionality. So, and that's really formulated in the third sentence of 8.37 at page 3755. In particular, the first panel specifically raised issues of whether section would be unconstitutional if it was not interpreted so that a judge should require the attendance of an expert, where that witness was an important witness, was available or not shown to be unavailable, and the defence expressly required his attendance for cross-examination. We submit that the Court of Appeal's decision to uphold the judge's ruling was flawed, by their reasoning that the first appellant needed to identify some special reason to ensure the right to cross-examine. Well, we put in the reply that it is a good enough reason that I want to test the evidence. That's 6.2 of the reply at page 5498. That there was a clear understanding that Mr. Stubbs' counsel wanted to explore, probe, and test his evidence, and he said so at 1894, 1895 to 1899, and he had already identified in the second trial that he wanted to test for issues of continuity. But also that's the way we put the point about constitutionality and fairness. But just turning to, was it in the interests of justice, applying the section 120 subsection 2 test, that's ground 4, and we say that judge had found it was in the interest of justice that Higgs be called. And my lords, once he made that finding, it conferred a right on everybody to cross-examine. Obviously, the judge said, "I find it's in the interest of justice to be called. Take steps for him to be called," and all three appellants would have had the right then to cross-examine. The court found at this 9.3 the judge's decision to admit the report after he found in the interests of justice that he should be called to be perverse and that it prejudiced the fairness of Evans' trial. We say, and I think I've really dealt with this point now, that there was no proper distinction or fair distinction between the position of the first appellant and that of the third appellant. And in both cases, it was the right to test an important and prejudicial forensic finding. And we say that all the principles that I cited to you from the Court of Appeal's reasoning at paras 200 to 204 are equally applicable to the first appellant. And indeed, Hartman-Longley, Justice Appeal Hartman-Longley in his support seemed to say exactly the same. And my lords, then the rest of it is really set out in our reply. We make the point that there must only, in the reply, that there must only be limited exceptions to the right to cross-examine. That's at 5.6. And we submit that the interests of justice test should be interpreted in the broad way that we advocate. Now, we've responded to my learned friend's points at part 6 of the reply. In essence, he says Stubbs had simply not given any reason. We say, yes, he had a perfectly good reason. I want to test this evidence, and that's at 6.2. And then they say that there was no disadvantage. And we say that there was a disadvantage because the casings retrieved could have been fired from a .45 gun of any one of numerous makes. That's at 6.6. And we dealt with the point, well, that wasn't your defense. His defense that the gun was not his does not mean that it was not a nail in his coffin if it was admitted that the gun which was allegedly linked to him was linked to casings. Indeed, it gave a powerful boost to the prosecution's case, as the judge himself indicated when he summed up in the way he did. And I've taken the court to that already. The prosecution particularly rely on that point. And we've made the point at 6.8 that the point was taken in the earlier trial. And we say that there was prejudice and disadvantage to the first appellant, which rendered his trial unfair. Well, those are our grounds why we say that the admission of Higgs's evidence was wrong in the judge's reasoning, and that the Court of Appeal were right. They were right to say it should have been admitted, but wrong to say that there was no unfairness to this appellant. And again, they as it were stood the common law and constitutional right on its head, saying you produce a good reason why you should be entitled to test the prosecution case. And my lords, in any event, if it was admitted, there should have been a special grant style direction, and we've given you the reference to grant, particularly at page 10.1 at page 3757. My lord, those are our submissions on conviction, unless I can be of assistance on the conviction point any further.
Well, thank you very much indeed, Mr. Fitzgerald.
Oh, then, my lord, the only short point is on sentence, where there's a good deal of agreement.
Yes.
Can I just, so I can take that in a few minutes. On sentence, as we've set out in our reply, the prosecution agrees as to the way that the sentence should be computed, so that the 45-year sentence begins from 2013 with the time spent in custody deducted from that. And that actually does lead to a shorter period in custody at the end. And we agree with my learned friend, Mr. Knox's calculations as to what the proper entitlement should be. And to the extent that the Court of Appeal approached it from a different point of view, there seems to be agreement between us that was wrong. The other point that we make is, yes, this was a reduction of the sentence from life to 45 years. That's in accordance with the general principle now adopted by the Court of Appeal in Bahamas, that it's more appropriate to give long fixed-term sentences than life sentences because of the unknowability and indeterminacy, as it were, of the life sentence.
Yes.
So they substituted 45 years. And of course, since that's what we were asking for, a long fixed-term sentence rather than a life sentence, there's no quarrel with the fact of a long fixed-term sentence. However, we do submit that in their reasoning, the Court of Appeal failed to make a reduction from the sentence that they regarded as otherwise appropriate to reflect the breach of the appellant's constitutional rights. The court has the point, which is shortly taken at page 3758, that there was, first of all, there'd been a specific judicial finding that the first appellant's constitutional rights had been breached by the inordinate delay of 14 years in bringing the appellant to trial for the third time. And this had violated his constitutional rights to trial within a reasonable time. And that ruling is in the bundle, in the record.
Yes.
My Lord, the second point, can I just, is of course he'd been subject for a period to an unconstitutional mandatory sentence of murder, of death. And after following the decision in Bow, the mandatory imposition of the death penalty in the Bahamas was held to be unconstitutional. Now, the question then is, did the Court of Appeal make any deduction? And the answer we respectfully submit is no. They had the argument was put to them, but if one looks at the sentencing remarks, and we've analysed this in the reply, at page 5501, yes, it was said, well, they would have taken it into account by my learned friend, but if you look at paragraph 228 of the judgment, which we analyse at page 5502, the court says the sentence should have been for a specified period of time, having considered the recent decisions of this court, particularly Poitier and Ellison Smith, among others. Now, those are cases about the need not to impose a life sentence, but a long fixed term sentence. We are of the view that the life sentence should be quashed, the sentence of 45 years imposed for each of the first and second appellants. There is no reference there to taking into account or making a reduction in respect of the constitutional breaches, though, as the court will see from the skeleton before the Court of Appeal, this was a point that was expressly taken before the Court of Appeal. There should be such a reduction. And so we say you can't just say, well, they must have taken it into account. The two cases they cite are not about reductions for constitutional breaches, but the undesirability of imposing an indeterminate life sentence rather than a long fixed term sentence. And we therefore say that there's nothing to indicate that the court concluded that 45 years would take into account the constitutional breaches. So our complaint is, well, if 45 years was the appropriate sentence to be imposed for these offences, then there needed to be a reduction to reflect the constitutional breaches. My lords, we've set out the various cases which reflect the need to mark the fact that there's been a constitutional breach, very often by a reduction in the penalty. And if your lordships would look at 12.5 at page 3759, the House of Lords in the Attorney General's reference, paragraph 24, that's the judgment of Lord Bingham, held that there had been a breach of the right to be tried within a reasonable time under Article 6.1, and therefore there had to be a remedy which is effective, just and proportionate. Where that breach had been established retrospectively, the appropriate remedy may be a public acknowledgement of the breach and a reduction in penalty imposed on a convicted defendant. So that's at volume 4, tab 70, at paragraph 24. And then there are two cases which we've referred to. One is the Boulel case, where the sentence was set aside and a non-custodial sentence was substituted because of the need to have regard to a reduction for a constitutional breach. My lords, Boulel is at tab 71, and the key passage is at paragraph 39 on page 5408, where and in Dharmalingam, the board went further and said actually the only remedy that's suitable is a remedy that actually sets aside the conviction as a whole, and that's at tab 73 at page 5437. But we say there has to be some acknowledgement of the breach and some remedy more than just saying, well, there's been a breach. And that has typically meant either a reduction of sentence, as in Boulel and as adumbrated in the Attorney General's reference case, or the more extreme thing of setting aside the conviction altogether in Dharmalingam, which obviously we're not seeking in this case. So, my lords, that's the first point. And then the second point is that there was, for a period, he was on death row under a mandatory penalty in further breach of his constitutional rights. And we've cited the two cases, the Belize judgment of the Chief Justice Conte in Belize, where the fact that the prisoner had been subjected to a wrongful death sentence and been on death row wrongly was held to be a reason for reducing the sentence, in that case from the death penalty to 20 years. And one of the reasons for not giving a life sentence but 20 years was the fact that he'd been subjected to breaches of his constitutional rights. And we've also cited the case of Cornwall. Can I just give the audit the reference? It's at page 5428, paragraph 74, and it can be found, yes, in the bundle at tab 72. And again there, this subjection to an unconstitutional mandatory death penalty was one of the reasons for a reduction in the sentence in that case. So there is no evidence that that important principle, which was advocated before the Court of Appeal, was taken into account, or that any reduction was made to reflect that principle. You cannot, by any stretch of the imagination, infer it, imply it, or necessarily imply it from paragraph 228 of the Court of Appeal's judgment. And therefore, we submit that at the very least, if all else were to go against us, there would be an entitlement to remission for that issue to be reconsidered by the Court of Appeal. Unless I can assist.
Thank you very much indeed, Mr. Fitzgerald. And you've told us that your junior will not death row, is that right?
That's right, my lord.
Well, I think we'll need to have a little break in order to allow Mr. Thomas to set himself up. Okay, so we'll break for a
Yes.
few minutes.
My learned friend is saying he's ready to go, but it's a matter.
Yes.
He's happy to have a break.
No. Well, if he's ready to go, well, let him go, so to speak. But we may have to be counted down again. Do we, Jason?
My lord, can you hear me?
Yes, I can, Mr. Thomas.
I'm sorry, we just had to. I'm just wanting to connect. Has the echo disappeared?
Right.
Yes.
Right, Mr. Thomas.
My lord was kind enough to indicate that the court has had an opportunity to read the written pleadings and the material in this case.
Yes.
And happily, the written case that was filed on behalf of the second appellant represents the position I wish to advance today. And therefore, I propose to use the time available to me to, in relation to ground one, the Scott point, simply to make 3 short points responding to what my learned friend, Mr. Knox, has said in the respondent's written case, and then move on to deal with the hearsay identification evidence and just clarifying and developing a few short bits from my written case.
Yes, thank you.
And in order to do so, my lord, the written case of the second appellant can be found at electronic bundle 3804. And I will also be referring to the treatment of the second appellant's case by the respondent, which is in the respondent's case commencing at 3837.
Yes.
And what I say in relation to the Scott point, by way of response to Mr. Knox's points, is this. Firstly, it is said that counsel representing the second appellant did not seek to have excluded in particular, the prejudicial evidence of the arrest. Now, what we say in response to that is a little like Mr. Fitzgerald said, there was an opposition to the whole, and with the whole comes the part. And in fact, at paragraph 75 of the respondent's written case, at 3837, can be found what was said by counsel for the second appellant. He says, my lord, can I add something on behalf of Mr. Davis? Mr. Davis, at the time this witness had been called, as quite rightly pointed out, was unrepresented, and he did cross-examine, but he is a layperson, my lord. My lord, I would ask my lord to take a look at 178 of the Evidence Act, and I would just leave it at that. Well, I acknowledge, my lord, that that's putting the point rather succinctly, but in circumstances where the reference there must have been to the cross-examination in the deposition by Mr. Davis himself, in which he put in his previous arrest. He put in an arrest which led to the evidence coming out of the fact he was arrested in relation to firearms and threats of death, which is highly prejudicial. That's plainly what Mr. Cargill was referring to. And that it was a matter for the court as to whether they excluded the whole or the part. So we do say that to the extent there is a criticism that there was no application to exclude, that does suffice. The second point that is made in my learned friend's skeleton is that the argument that the prejudicial material in particular should have been excluded was not a point taken in the Court of Appeal. It's one made at paragraph 77 of the respondent's case at 3838. And I don't propose to take the court to it, but at electronic bundle 3312 at paragraph 8, it's plain from the skeleton argument in the Court of Appeal that this point was taken. And finally, it is said by the respondent that, well, it wasn't in any event quite so prejudicial. And my submission on that is that in a case which included the current case, a murder using a firearm, to voluntarily adduce evidence that he had been arrested for what was threats of death and questioning for a firearm, and that's electronic bundle 214 and 215, that is particularly prejudicial material. And so, other than the way in which the case is set out in our written case, those are the three additional points I would want to make, replying to what the respondent has to say.
Yes, thank you.
And moving on, therefore, then to the hearsay ground, which is at paragraph 9 of the written case at 3808. And I've set it out, but in summary, the court will be familiar that this is the evidence that others in the crowd had pointed to Mr. Davis and made accusations against him. That evidence comes from Officer Duncombe, who said 4 or 5, and also Mr. Scott. My lord, the court will have seen that the Court of Appeal at paragraph 178, which is electronic bundle 3392, made reference to this hearsay evidence coming from officers Ryan and Duncombe. That's an error from the Court of Appeal. It is evidence, as I've set out in the written case, from Scott and Duncombe. And on that point, what I do need to do at this stage is just to clarify, and certainly not correct, but just to clarify one point in the statement of facts and issues. Can I take the court to 3686? And it's paragraph 10.12 of the statement of facts and issues. And it says there that Mr. Davis was in the group, and the officers heard others in the group shout that Davis was one of the men who shot the policeman. Davis did not say anything in reply. There are references there to Ryan as well as Duncombe. firstly, the reference on the fifth line down should be 1353, not 1352. And secondly, at that stage, in relation to Mr. Ryan, prosecuting counsel was being rather more coy when he gave his evidence. And as the officer began to elicit evidence of what others had said, he was interrupted and he said, "You received certain information." So to the extent that there is an implication there that Ryan also gave evidence about what others have said, that's not correct. All he said was that it gave certain information. And so as in the written case, it is officers Duncombe and Marcy and Scott. So I just clarify those references.
Right, thank you.
Can I take the court back to my written case of paragraph 10?
Yes.
We say this, that it is true that hearsay evidence may be admitted pursuant to section 39(2)(d) of the Evidence Act, but that is a discretionary exception to the rule in 39(1) that hearsay evidence shall not be admitted. And the error that the Court of Appeal fell into, we say, is that what they proceed to do at paragraph 180 is to treat the words may as reading shall. And in paragraph 180, the court says that this evidence is admissible under the section. What we say is that the correct word is may, and that plainly it can only be admissible if it can be evidence against the defendant. And if it is to be evidence against the defendant, we set out at paragraphs 11 the way in which the common law has treated accusatory statements and their adoptment by a defendant. We say the common law here is perfectly consistent with the provision in section 39, in that it may be that statements made in the presence of the hearing of a person evidence tendered where the person has had an opportunity of replying to such statements may be admissible, but that's only when they can be evidence against the defendant. And we the only authority I'm going to take my law to in the time available to me is Collins. And that's at bundle 2 of the authorities bundle. It's at page 4, the relevant sections at 4401 of the electronic bundle. Paragraph 28 through to paragraph 34, the review of the law. I don't need to take the court to all of that because in essence they all affirm the common law position set out by Lord Atkinson in the Crown and Christie 1914 AC 545, and that an accusatory statement made in the presence of an accused person, the key bit is not evidence against him of the facts stated so far as he accepts the statement so as to make it in effect his own. And the authorities address circumstances where it might be that silence could amount to acceptance. And the conclusion at paragraph 34, having reviewed the authorities, is that from the authorities to which we have referred, it is clear that where an allegation is made against the accused in his presence, it is for the jury to determine whether a statement made in the presence of the accused causes some response. If it does, and if no response is made, the statement can only be evidence against the accused if, by his reaction to it, he accepts that the statement is true. Although that is a question for the jury to determine, mere silence of itself cannot amount to an acknowledgement of the truth of an allegation. And so two things flow from that, we say. Number one, on the evidence in this case, it's plain that in response to the accusatory statement coming from the crowd, that Mr. Davis denied them, and we've set that evidence out at paragraph 12 of the written case. And so we say, removing the split infinitive there, it would have been impossible for the jury to conclude safely that the second appellant had made no response. And to the extent it is a matter for the jury, can I rely on paragraph 36 of Collins, where the court makes it plain that to go before the jury, there had to be an evidential basis for that. And so in Collins, there was a silence there. They said mere silence was insufficient, and that wasn't a sufficient evidential basis for leaving that jury question to the jury. And so in our respectful submission, he had not accepted the statement. It could not be evidence against him, and there was an insufficient basis to put it before the jury. And in those circumstances, the discretionary power in section 39 should not have been exercised. And we say the error of the Court of Appeal was to treat the discretionary power in section 39 in effect as a mandatory power. And in those circumstances, we respectfully submit that what was very damaging evidence, the denunciation by the crowd, in Duncombe's case of in an angry way by four or five people, is evidence that should not have been admitted. In those circumstances, my lords, that is all I seek to say in addition on ground 2.
Yes, thank you.
As to the other matters, the fresh evidence ground, I rely on what's been said by my learned friend, Mr. Fitzgerald. Plainly, the credibility of Mr. Scott is at the heart of the proceedings. As to what my learned friend, Mr. Knox, says about proviso, I will save that and deal with that in my reply.
Yes.
And having heard what else he may have to say, and in relation to sentence, we make the same submissions in terms of adopting the constitutional breaches, asking for a further reduction from that. And as Mr. Fitzgerald has set out, it appears that all the parties are in agreement that the date the sentence should have run from is the 30th of October of 2013. I think I have a few seconds left. If my lord could just give me a moment to make sure I've
yes, of course.
made the submissions. Yes, unless I can be of any further assistance.
Thank you very much indeed. Mr. Knox.
Hello?
Hello.
Ah, my lord, sorry, I thought I'd gone off. My lords, can I deal first with the admission of the evidence of identification evidence of Campbell?
Yes.
My lords, I just want to make two preliminary points, which I submit are fundamental. And the first is this, that the vice of a dock identification is that the witness is influenced by seeing the man in the dock into honestly but mistakenly believing that he is the man whom he saw commit the offence, when in fact he was not. and the explanation for that has already been referred to you by my learned friend, Mr. Fitzgerald, but you'll find it in Holland at in bundle 2, tab 36, paragraph 47, at page 4592. And my lords, I submit when one looks at this case, I submit it is fundamental to bear in mind that that is the vice which is sought to be prevented by what are called doc identifications. And in my submission, on any view, there is no sufficient basis for supposing that Campbell would have pointed to Stubbs in the dock at the trial just because he was there, or indeed would have been influenced into doing so because he saw him there. That's my first, what I call preliminary point. My second is this: even if there had been an identification parade, the evidence, or rather, even if Mr. Campbell's evidence of the identification parade itself should have been excluded, it would have been perfectly permissible for the judge to admit the rest of his evidence. That is to say, that he had seen this man, whom he knew as Di of Ridgeland Park, as one of the people who joined in the attack on the deceased. Therefore, in my submission, the admission of the evidence of the identification parade itself caused no substantial miscarriage of justice. My lords, those are my two main submissions. My lords, I also submit this, just on the facts. One must consider the question of whether or not the Campbell's evidence of the identification parade should be admitted against the two contemporary statements he made on the 29th of March and the 30th of March. And my lords, can I just ask you to take a look at those? And my lords, the question these go to, the really important question these go to, is the exercise of the judge's discretion, assuming for the moment that a more broadly put case has been put to him by both parties. Because I submit, once one looks at these two statements, there was every reason for the judge to say, I ought to let in this evidence from Mr. Campbell of the identification parade, because he plainly saw him, or thought he saw Mr. Stubbs at that parade, even if maybe he didn't actually point him out to Inspector Mackenzie. But there was plainly material on which the judge could properly find that he recognized, that Mr. Campbell recognized Stubbs at the parade, from which he could also draw the inference and leave it to the jury that he pointed him out to Mr. Mackenzie, or Inspector Mackenzie. And the converse is also the case. What you've got here is two documents, one in particular, contemporary documents, which seem to indicate that Campbell did say something to the police. In those circumstances, to exclude his evidence to that effect on the basis that Inspector Mackenzie's evidence was correct, or necessarily correct, I submit would have been wrong in principle. And my lords, if I can just take to the two statements, the more important of them is the second statement, but in fairness, one has to look at both statements to get what you might call the whole picture. And the first statement is one which he made before the identification parade, and he makes it on the 29th of March, before the identification parade. The second is made on the 30th of March, after the identification parade. And you can see them, conveniently enough, right at the beginning of the first core bundle. And the first statement is at page 23. My lords, I'm not going to read all this out, but I'm just going to take you to the material parts. You can see at page 23, a statement made to the police. You see the date of the statement near the top, 29th of March, 1999. On the first page, 23, he gives a description of seeing three men come up, but he doesn't say much about them. And then on the second page, if one can pick it up, please, from page 24, about halfway down, you can see a sentence beginning further where across the line. He grabbed the officer. Now, what he's so far been talking about is Mr. Davis, who was wearing, I think, white, grey and black camouflage pants. But he says he grabbed the officer. So Davis, on this account, is the, what you might call, instigator. He grabbed the officer and threw him down on the ground. And he started kicking him about the body. And he was joined by the other two men. The three of them had handguns in their hands. And I heard 4 shots fired at the officer who was on the ground. After that, they pushed their guns back into their waist and they walked off to the yard, walked off out of the yard. And then he says, shortly afterwards, I noticed the officer was shot and blood and so forth. And then he goes on at the foot of the page to talk about the same man, it's about 4 lines up, 5 lines up, the same man who was, I think, dressed in the grey, white and black camouflage outfit. Now that's Davis, came walking back into the yard and I pointed him out to the officers along with other persons who also said he was there. And the officers took him, that's Davis, away. The man who was wearing the camouflage, I think it's, I'm not sure if it says suit, is about 5 foot 10 inches tall, medium built, dark, I think, not quite sure what it next says, something complexion. The man who was wearing the black pants and red shirt, and that would appear to be Evans, is about 5 foot 8 inches or 5 foot 9 inches tall, medium built, dark complexion. The other man, so this one is the third man, not Evans and not Davis, is light brown complexion, medium built. I cannot say what he was wearing. I can identify all of these 3 men by face, if seen again. Now, obviously, my learned friend says, well, look, he doesn't mention anything about the chap he knows called Di. I think it's on the same day, the 29th of March, that the parade takes place. My lords, I'll have to check whether it's 29th or the 30th. But in any event, after the parade, you have the statement he gives at page 26 on the 30th of March. Each of these statements, I should say, my lords, was written out by the police officer. They're not written in his own hand. He simply signs them. And he says in this second statement, which if I may read it short, if I may read it out, I am the above mentioned person and resides at the mentioned address. On Tuesday, 30th of March, at about whatever it is PM, I attended an identification parade at Traffic Police Station, at which I identified 2 males who I saw on Monday, the 29th of March, 1999, sometime after 1:25 a.m. at Club Rock West, Bay Street. One of the males who I identified, I don't know his name, he had number 10 on his chest at the time of the incident. He wore grey camouflage pants, white shirt, camouflage, and a fisherman's hat, and that's Davis. I saw him lift the police officer, and throw him to the ground. I saw him lift up the police officer, and throw him to the ground, and started stomping him, and he then pulled out a gun and fired it at the officer. This fellow is also of heavy build. Other man I identified was number 2, a man I know as Di of Richland Park West, who also was kicking and stomping the officer. I have known Di for about 8. My lords, it appears to be common ground, that means 8 years. And the last time I saw him was when he came into Club Rock with some fellas. After they had shot, I think, the officer, they just walked out of the club yard, signs it, and then the police officer countersigns. My lords, I do submit those are very important statements to bear in mind when one is considering the question of the judge's exercise of discretion. How ought he to have exercised discretion, given that you've got those 2 statements, contemporary statements, as to what he says he saw, but in particular, in the second statement, what he says happened at the identification parade. And it is, of course, a rather unusual case. And my lords, I submit what is unusual about this case is you've got a conflict between the witness, as to what happened at the identification parade and the officer who conducted it. And the real question is, I submit, does it follow, when one looks at all facts, that the judge was bound to exclude this evidence of the identification parade itself? And I say plainly not, it doesn't follow at all. My lords, there are two ways of looking at the exercise of the judge's discretion. The first is on the basis of really the very narrow arguments and limited material which were put before him. And I say on that basis, he came to the right conclusion. There is another way, which is really implicit in my learned friend Mr. Fitzgerald's argument, which is, let's have a look at all the material which should have been put before the judge. Again, I say, my lords, so far as that is the right way of looking at the matter, there is no basis for saying that the judge came to the wrong conclusion in admitting the evidence. In other words, whichever way you look at how the discretion should have been exercised, the judge has done nothing wrong. My lords, dealing with the first way of looking at the matter, how was the matter left to the judge? And my lords, this does involve going back, just briefly, if I may, through the way the arguments was put to the judge before the admission, before he made his decision to allow the evidence of the parade to be given. And that involves going to bundle 2, and one can pick it up initially, if I may, at page 361. And this is in the examination in chief of Mr. Campbell, and one can pick it up. And my lords, bear with me if you may. I just want to show you the context and what Mr. Campbell had said by the time the voir dire took place. Page 361, line 22. Now, he has already described how he's already described the lighting and things like that, and he says it was well lit, that sort of thing. He then describes how Davis does the attack on pages 360 and 361. And then at 361, line 22, he describes what happened when he saw the other two gentlemen joining in. He says, shortly after that, I saw 2 other gentlemen. They ran past me, and they joined in, and they start stomping and joined with him. And they start stomping and shooting at the officer while he was on the ground. And the first man licked the officer down. Where did the officer land? Just about 7 or 8 feet from the truck. Then he's asked to describe what that means. And then he's asked at the foot of the page, the other 2, when you say they ran past you, how close did they get to you? They passed like 6, 7 feet away from me. Were you able to see their faces? Yes, ma'am. No need to point anyone out, but were you able to see their faces? Yes, ma'am. Were you able to see what they were wearing? And then he describes what I think it's Davis was wearing, tannish light outfit. And the next fellow had on a red shirt and black jeans. That appears to be Evans. What did these 2 men do? They went and joined in. Sorry, my lord, I think in fact the tannish light-coloured outfit man must be, he's referring to Stubbs. They went and joined and was beating up the officer, and they pulled out the gun, each one of them shooting at the officer while. How many had the gun? 3 of them. One had a black gun, the next one had a chrome gun. And then he's asked, was anything obstructing your view of these men at the time? No. How long would you say this incident took place? About 5 minutes. 5 minutes. When these men were stomping the officer, what were the officers doing? He was on the ground. After they stopped the officer and shoot at the officer, they put their gun in their waist and they exit the western gate and they're heading to cocktails. And then he's asked, was that the first time you'd seen these men? After they reached and they were stomping on the ground, then they pull out their gun and so forth. My lords, one can then, so that is the evidence which has been given before the voir dire takes place. He then goes on at page 366 to identify, this is still before the jury, to identify Davis, to describe what happened at the identification parade so far as Davis was concerned. And he says at 366, about line 22, that he identified the man at number 10. That's Davis. And then at page 367, there is a voir dire, and you can see at the top of 367, line 2, the jury leaves, and then the next bit's heard in the absence of the jury. My lords, if one then goes to 367, my learned friend took you to this extract from Mr. Ducille's argument. His argument is simply the witness didn't identify on an identification parade. So that's Mr. Ducille's argument. If one then goes on to 376, now in answer to a point made on behalf of Evans, but this in my submission shows his line of thinking, and I submit correct line of thinking. He says, 376, line 11, the court, we don't get to the prosecution's case yet, remember that. Ms. Foxton, you exercise your discretion, my lord, pursuant to section 178, and prevent this witness, my lord, from leading or pointing out in the dock my client. Again, my lord, the prejudicial effect. If I was to probe or cross-examine or suggest to him that you refer to number 2, then significantly he says, there has to be sufficient evidence for this to go to the jury. Remember, please. So what the judge is thinking at this point is, I submit it's quite obvious, his line of thinking is, well, if this evidence is completely and utterly tenuous, then I'm not going to let it in. But really, the more appropriate time for dealing with these types of objection about the weakness of identification evidence is actually at a half-time submission, not at the moment of deciding whether or not to allow evidence of a parade in. And then,
sorry to interrupt, Mr. Northwood. If it had been established that Campbell had not identified Stubbs at the parade, let us suppose there was unequivocal evidence to that effect, but purported to identify him in court, would that evidence, should he be allowed to carry out a dock identification?
My lords, in principle, it wouldn't of itself be admissible, but I would accept this. So much turns on the facts. Supposing you imagine this case, the very first time, let's say in 1999 you have the offence. There has never been an identification parade, let's say. There's no contemporary material to support the allegation that he did make a contemporaneous recognition. And then 20 years later, or 10 or 5 years later, hey presto, he suddenly makes an identification of a man in the dock. I would submit it's unlikely to be right in those circumstances to allow what you might call a pure dock identification to be made. And that would be because the circumstances, one always needs to know the exact circumstances, the circumstances would be such that it would be a very serious risk. He would simply say, yes, that's the man who did it, because the man is in the dock.
Yeah.
Accept that much.
Well, let's suppose he claims to have made an identification at the identification parade.
Yes.
But convincing evidence, establishes that he did not make that identification. Should he be permitted to make a dock identification in those circumstances?
If my lords, I don't want to sound, my lords, I'm being difficult.
No.
You can imagine the answer I'm going to give. It depends on how convincing that evidence is. If it was simply overwhelming, if you'd say, well, look, there's no two ways about it. We've got evidence that he wasn't even at the parade, or we've got evidence, we've actually got a tape recorder. Things like that. The judge might say, well, look, there's no way this evidence could be accepted by the jury. Mm-hmm. If it reaches that level of implausibility, I would accept, my lords, the judge might say, look, I'm just not going to let this type of thing go to the jury. But in my submission on this case, and you have my submission, it doesn't get anywhere near that level of implausibility.
Well, not only does he not allow it to go to the jury, but he refuses to permit Mr. Campbell to make the purported dock identification. Is that right?
Well, no. He lets he does in the end. I mean, Mr. Campbell does indeed make an identification of. No,
I'm asking you to imagine.
Yes.
The circumstances in which it can be shown unequivocally that notwithstanding his claim to the contrary,
Yeah.
Mr. Campbell did not make an identification at the identification parade.
Yes.
If that is shown to be a wrongful claim, then he should not be permitted to make a dock identification. Is that right?
Yes. If it is clear, well, rather, if it is clear to the judge on the material put to him at the time, then he should not allow the evidence to go in. I suppose one might also say, if it is clear retrospectively from what you might call new evidence or some sort of clear, indisputable evidence, which just happened to get missed out when the judge was considering the matter, then again one might say, now I see everything. I'm prepared to accept that that the judge simply shouldn't have allowed this evidence to go in.
Right. Well, if, as in this case, according to the appellant's case, there was substantial reason to question Mr. Campbell's claim to have identified at the identification parade stage, to have identified Mr. Stubbs. The principal reasons for questioning that are, first of all, the evidence of Inspector Mackenzie that he didn't, and secondly, the conflicting statements that he made as to whether he did in fact make an identification of the ID parade. While on your case, the judge could still allow a dock identification to be made, was it not incumbent upon him to warn the jury very stringently that they had to treat that evidence with great caution?
My lords, he would. I would accept that he would. He should give a warning to the jury that if they rejected Campbell's evidence, then it followed that he wasn't. It followed that he didn't make an identification at the parade itself. I would accept he's got to do that. My lords, I don't accept that there's some sort of general principle that requires a judge, at least of all on the facts of this case, to give that sort of warning. My lords, if I can jump ahead a little bit, the reason I say that is this. If the judge was going to start getting into directions like that, he would, in my submission, have to give a countervailing direction to the effect that immediately after the parade, on the same day, it's the 30th in both cases, Mr. Campbell had indeed said.
I made a statement, yes.
I made a statement, and I said it was arrived. My lords, I submit that was rather damaging. One of the curious things is, because it might be said, the countervailing advantage Mr. Stubbs obtained from what you might call the judge not giving the sort of direction you say, is that he doesn't get the damage that would be done by a direction saying, you might like to consider, members of the jury, that immediately after the parade, he said he recognised this chap called Dyer of Richmond Park, albeit with the wrong number. But nonetheless, my lords, that's pretty telling stuff. My lords, I can't remember if he says I pick out or identify. It might just
I don't think it signifies for the present, but you're right. He did make a statement more or less immediately after the identification parade, in which he did say that he had picked out or identified Mr.
Identified is the word he used. I'm just checking. He said I identified. The other man I identified was #2.
Yes,
which suggests not only I recognised, but I said I recognised.
Yes, thank you very much.
My lords, I would accept, and of course I would accept, and if it were not for the two statements on the 29th and 30th of March, I would accept it would have been right for the judge to say, members of the jury, treat with very great caution this evidence, because of course it is contradicted by the inspecting officer, by Inspector Mackenzie's evidence, and indeed Mr. Campbell gave different evidence at the second trial. The difficulty is, first of all, no one brought up at all, either before the judge on the voir dire or before the jury, that Mr. Campbell had given different evidence at the second trial. So the judge, in my submission, couldn't possibly go into all that. And therefore, the only thing the judge at the summing up stage had before him was the conflict between Mackenzie and Campbell, and Campbell's contemporaneous statement. Now, in those circumstances, I submit no criticism can be made of the judge for dealing with it exactly the way he did, saying there's a fundamental conflict between the two. And it would have been, my submission, been wrong, if I can put it this way, to say pay more attention to one person's evidence than to another's, bearing in mind the actual rather unusual facts of this case. Right. That's what it comes to. Yeah. My lords, I was going to go through, but I can perhaps cut it short. The way it was put to the judge, when one looks at it, my learned friend took you through the arguments. One point, my lords, I do submit. It was not told to the judge that Campbell had not made an identification at a parade in the second trial. He doesn't say nothing of the sort says that. There is a passage where Mr. Ducil says the prosecution should know their own case, or words to that effect. But it was not argued before the judge that Campbell's evidence was ex hypothesi unreliable, because he didn't make he accepted there was no identification at the second parade. So the judge, in my submission, couldn't possibly be criticised for not taking that point into account. It just wasn't made. Really, the only point that was made before the judge, in substance, was that Mackenzie contradicted Campbell, to which the judge says, well, that's a matter for the jury, isn't it? In my submission, that's quite right.
Yes.
And the judge is entitled to exercise his discretion by saying, well, I'm going to leave that to the jury. My lord, subject to this point, of course, if the evidence otherwise had been so weak, the reason I drew your lordship's attention to this, the judge would, of course, still have a discretion at half time, if he's admitted the identification evidence in, or parade evidence in, to chuck the case out at half time if the evidence is too weak. So, my lord, that's what I say, what you might call the short point. How was the matter left to the judge? I say, given the way it was left to the judge, nothing wrong in his decision. He was entitled to leave it to the jury. My lords, the other way of looking at the matter is supposing everything had been put before the judge, and supposing for the moment, in principle, it's admissible, or it's proper to look at the case that way. I say, if one looks at the case that way, you get to the same result. And if I can put what you might call the competing arguments on either side, which the judge, let's say everything had been put before him, what would the competing arguments have been? Well, on the appellant's side, Mr. Stubbs' side, there would have been taken on its own Mr. Campbell's first written statement on the 29th of March 1999, where he doesn't actually mention die. That's his first point. The second point he would make is Inspector Mackenzie. There's a contradiction between Inspector Mackenzie. And the third point would be the evidence at the second trial about the identification parade, when Campbell says, I didn't pick him out of the identification parade. On the other hand, what the Crown would be saying is, first, the obvious point that Stubbs was actually at the scene. This isn't a case of picking someone out who was nowhere near. It's common ground, he was there. Of course, that doesn't avoid the risk that you pick out someone because you saw him there and you mistakenly translate that into your mind into thinking he was one of the attackers. But even so, that's a point one would take into account. Second, the Crown would obviously argue that the 30th of March 1999 contemporary statement, there was very powerful evidence that he did pick out more than one man. He must have done. And so Mackenzie's just wrong when he says he only picked out one man. Thirdly, that same statement clearly gives rise to the inference that he recognised Di of Richmond Park. There's just no doubt that Stubbs' nickname was Di, and he was from Richmond Park. So one is here talking about the risk of mistaken but honest, an honest and mistaken identification. But if he's actually managed to do that honestly, it's difficult to see how he's mistaken. The only real way around that bit of, what you might call bit of that evidence, is to say it was planted by the police. Now, my lords, there's no suggestion of that. And anyway, that doesn't go to the question of block identifications. The next thing which the Crown would say is, well, Campbell did make a positive identification of Stubbs at the preliminary inquiry, albeit he muddled up Stubbs and Evans, because he said he was frightened. He wanted to get out of having to give evidence. My lords, the reference for the preliminary inquiry evidence is bundle 8, page 2790, at lines 12 to 32. The next point would be that at the first trial, Campbell did, again, give evidence that he had made the identification at the parade itself. I think bundle 1, page 40 to 42, and 53 to 54. 53 to 54, I think, is where he says how well he'd known him. Effectively, he says, I'd seen him around at Richmond Park and so on and so forth. He gives similar evidence at the second trial. And then at the second trial, he also, bundle 1, 71, lines 23 to 74, gives evidence of the threats which have been made to him. He says, well, the reason I have been, I've been awkward about this is because I've been threatened. My lords, it may or may not be the case, but all this is perfectly credible evidence on its face. My lords, again, in taking into account what should have happened at the voir dire, you look at the second evidence trial. Now, it is true that at the second evidence, I think it's at volume 8, 3136 to 3137, Campbell says, I didn't make an identification at the parade. So he goes back on what he said first time round. This is now in 2007, 8 years after the event. But he does, and he did give evidence about knowing this chap called, or knowing Stubbs as Di. And that was at volume 8, 3138, line 13 to 14. And importantly, my lords, what is so important is it was not challenged at the second trial that he knew Di, or would have recognized him. Mr. Ducil didn't cross-examine on the basis you're making all this up when you say you know him. And the cross-examination is at volume 8, 3140 to 3152. And then again, at the second trial, he gives evidence of his fear. And that's at 3179, line 4 to 3181, line 29. So you've got an explanation, my lords. You have an explanation for why he has been difficult with his evidence. So now, in my submission, the judge, properly taking all that material into account, if he'd been asked to by both sides, would have said, well, there's plainly a case for saying he did make a positive identification at the parade. There's quite a lot that might need to be looked at here, but I'm certainly not prepared to kick the evidence out just like that. It's perfectly possible that actually, in particular, 2 people were picked out because of the contemporary statement, and that one of those was Di, and that the numbering has simply gone wrong, or that Mr. Campbell was frightened. My lords, also at the third trial, I think I drew this to attention, even before the voir dire, Mr. Campbell did give evidence that he knew the man in the tannish outfit while living at the Yellow Elder for 8 years. So that evidence will come out at the third trial. So I say the proper approach for the judge, let's say everything had been put in front of him, but we'd say, well, all this is a matter for the jury. I'm certainly not prepared to say Inspector Mackenzie has to be right, because there's contemporary written material to the effect that he was wrong. My learned friend, Mr. Fitzgerald, says that there are no notes. It's true, there don't appear to be any notes that we're aware of from Inspector Mackenzie. We just don't know, I'm afraid, whether or not there were ever any notes that he made. I accept, my lords, this much. When the Court of Appeal said that positively that Mr. Inspector Mackenzie was speaking merely from recollection without notes, I'm not able to uphold that particular part of their reasoning. He may or may not have been speaking with or without notes. I just can't say. But I say that even if the Court of Appeal was wrong, that's not a material error, bearing in mind all the other material I've mentioned. My Lords, if I can just summarise what I say on the question of discretion. First of all, there was sufficient material to support a case of recognition. Secondly, and crucially, the risk that Campbell would identify Stubbs in the dock just because he saw him there at the third trial, it was, in my submission, non-existent, or not a real risk. That's what I say on the parade itself. My learned friend says you've got to be careful about recognition cases. I agree with that. The mere fact there's a wide range of what you might call recognition cases, which is why it's a bit difficult sometimes just to look at other cases and say, well, look, my case is a bit like that. But one point I would like to make is my learned friend refers to Fergus. Now, my Lords, that was not a dock identification at all. It was a case about a young boy who was 13 years old, who was wrongly accused, as it turned out, of being a robber. And what had happened was that the identifying witness had been robbed. He says he looked out for his attacker over the next 4 weeks. And then I think when he was on a bus, he had a fleeting glance of his attacker once again, and at which point he's, I think, chased after him, but identified him. He was convicted, and the Court of Appeal overturned the conviction on the basis there were so many errors and so many weaknesses in the identification evidence that you couldn't possibly uphold the conviction. Now, my Lords, that was, of course, what you might call a quote recognition case, only at the totally opposite end of the spectrum. I don't know this person at all, but he did attack me 4 weeks ago. My Lords, this is not what you might call at the opposite end of the spectrum. The reason I say that is this: how is it, assuming for the moment that Campbell is honest, how is it he's able to give details, A, of the name, Di, and B, of the place? He knows too much. So he obviously does recognise this person. Of course, he might be wrong in saying he's one of the attackers, but he recognises him sufficiently, in my submission, to allow for the identification parade evidence to go in. My Lords, my next point is this: supposing, for the sake of argument, that the evidence of the parade itself should not have been admitted, the question then is, and this, my Lords, appears from Goldson and France, the question is whether there's been a serious miscarriage of justice. I emphasise serious miscarriage of justice by allowing that evidence in. And my Lords, the references are, my learned friend, I think, took you to, I think, both cases. The references are: Goldson is at bundle 2, tab 34, and the page number is 4555, and France is at bundle 2, at 4542 in paragraph 28. And the question is, if there has been, assumed for the moment, a wrongful identification parade because the witness did not sufficiently know the accused, the question is serious miscarriage of justice. And so, my Lords, will then ask, well, has there been a serious miscarriage of justice as a result? And I say no. Suppose for the moment the judge had said this: I'm sorry, Ms. Allen, she was the prosecutor, I'm sorry, Ms. Allen, I'm not going to allow evidence of the parade itself to go in. The judge, however, would plainly have been right in allowing the rest of Mr. Campbell's evidence in, the recognition evidence about I saw this man and so on and so forth, I knew him as Di, and I'd seen him around for 8 years, and all the rest of it. It would have been plainly perfectly correct for the evidence to go in. No doubt, there would have to have been no questions asked about the identification parade by either the prosecution or the defence. Because otherwise he might, as it were, one way or the other, he might give up the judge's ruling. But leave that on one side. The way the evidence would have come out to the jury would have been no identification parade, but Mr. Campbell giving evidence of this chap. He had known her for about 8 years or so and seen him around in the pub, not just at the pub and things, but on other occasions as well. All that evidence would go before the jury. And most important of all, there would be no dispute in the cross-examination, as in this case. There was no dispute that Mr. Campbell knew Mr. Stubbs, as die. And my lords, the cross-examination in this case, from which that appears, is at bundle 2, page 388 to 398. So it wasn't challenged. His evidence of what you might call knowledge, which obviously is the foundation of the recognition application, wasn't challenged. That's a constant theme in this case. I submit, and my lords, what is significant is in those same passages, I think I'm right, I'm just checking my references, 388 to 398, the challenge that is put to Mr. Campbell's evidence is that he's dishonest. First of all, I think it's put that at the first trial, he had said that he'd seen Stubbs at number 35, not at number 5. That was one of the points of challenge. And my lords, I can't remember now what the other point of challenge was. I'll come to it in a moment, if I may. But it was essentially, you're being dishonest. And of course, my lords, that makes perfect sense. Because if one proceeds on the premise that Campbell does know Stubbs, well, that's about the only defence you've got left going. Especially if you know, and this was the difficulty in my submission, I can see why Mr. Ducil did this. The difficulty for Mr. Ducil was he couldn't really run a case of recent fabrication. Because immediately he says that, the prosecution pull out the 30th of March, 30th of March statement and say, well, that can't be a recent fabrication. Now, I should say that the 30th of March statement was before the court anyway, because there was cross-examination on it. But what couldn't positively be said by the prosecution in a positive way is this is not a case of recent fabrication. Members of the jury take into account that 30th of March statement. The prosecution couldn't do that exactly as things stood, but if this had all been opened up, they could have done. So, my lords, that's what I say in relation to the identification parade itself. My lords, the next question is summing up. My lords, we deal with this in our submissions at page, I think it's 3821 to 3823, where we run through what the judge says and the various directions the judge says about the need for caution and so forth. My lords, may I say, one of the problems, which perhaps I speak for myself, one sees these standard directions so often that they begin to wash over you. But as far as the jury are concerned, one imagines this is pretty new stuff. And so it does mean something when they're told to be very careful, exercise special care, and so on and so forth. So one shouldn't downplay the significance of the judge's Turnbull directions. And what I do in particular submit was actually right, was the way the judge dealt with it, was how he dealt with the conflict between Mr. Campbell and Inspector Mackenzie. And my lords, perhaps it might be worth just going to this in the summing up at bundle 2. And it's at page 550. At lines 10 to 15, you can see at this point the judge, I think, is summarizing the Campbell's evidence, and 10 to 15 he interposes this. Some of the evidence of John Campbell was contradicted by Detective Inspector Mackenzie. He was a detective inspector at CID on March the 30th, 1999. He was also the officer in charge of the identification parade at the traffic police station and so forth. His evidence was that the 3 suspects were on an identification parade. Campbell attended and picked out person number 10. The person at number 10 was the only person pointed out on the parade. And my lords, I submit that it's a clear direction, clear jury of a fundamental point. And then over the page, at 551, at lines 28 to 32, I must tell you that the contradiction between the evidence of John Campbell and Detective Inspector Rodney Mackenzie is fundamental. Both accounts cannot be true and are not reconcilable. It's a matter for you, the jury. And then he immediately continues, Madam Foreman and members, one of the rules which you will bear in mind throughout the case is this: the prosecution has a duty to prove the case against each of the accused to your satisfaction, so you can feel sure of their guilt. My lords, I accept that the judge doesn't go on to give what you might call the direction which Mr. Fitzgerald, as I understand it, contends. He doesn't say, now, members of the jury, if you reject Mr. Campbell's evidence on the parade and accept Inspector Mackenzie's, then I must direct you to take no notice of his evidence of the identification parade. But, my lords, one asks rhetorically, do the jury need to be told that? It's obvious. But there would be no cause for the judge then to go on to say, and I direct you also to reject the recognition evidence, or even really to make any comment on that, save for, well, you disbelieved Mr. Campbell on one point. Because the recognition evidence, what I call the recognition evidence, was not really challenged in cross-examination. So I submit there was no need on the facts of this case for the judge to go any further in relation to Inspector Mackenzie's evidence. And you have my points, which I've made in answer to my Lord Kerr earlier. If he had gone into what you might call a debate, or if he had started giving directions to the effect that Inspector Mackenzie's evidence should, in principle, be given greater weight, he would have had to have had a counterbalancing direction. To the effect, well, on the facts of this case, it rather looks as if Inspector Mackenzie might have got it wrong, because we've got a contemporary document saying so. My lords, one other point to bear in mind about Campbell. It is not alleged at all that he had any grudge or any reason to make up this evidence against Mr. Stubbs. Just none. So one is not here talking about a witness who's got an axe to grind. Wasn't put to him at all. That's what I say about what you might call the main objection to summing up. Not enough was made of Inspector Mackenzie's evidence. My lords, the judge does also remind the jury, I'll just give you the references. First of all, he reminds the jury in terms that mistaken identifications are clearly possible. And that's at 564, line 29 to 5654. He gives the standard term of direction, the special need for caution, and so forth, at 566, lines 10 to 23. And of course, he gives them the directions about the need to pay attention to the evidence about the lighting, obstructions, distance, and so forth. That's at 568 to 571. My learned friend also says that there appear to be breaches of the standing order. Well, the problem with that is the point just wasn't taken by anyone. Therefore, it couldn't have been a ground for excluding Campbell's evidence of the parade, nor could it be a ground on which the judge was to sum up. My lords, one has to be realistic about this. If a point simply isn't made to a judge at all by counsel, even though, as in this case, they certainly do have the opportunity of making submissions after the summing up, my lords, I submit one cannot make criticism of the judge on that basis. The other point I make on it is this: it can't be said that anything turns on it. How would it have made a difference if the judge had said, members of the jury, bear in mind that the standing orders make certain requirements to the effect that there should only be 12 people on the parade, and that you shouldn't have more than one suspect on it. In real life, my lords, how would that have made a difference? I submit not at all. My lords, another point that's taken against the judge's summing up is that he failed to direct on inconsistencies in Campbell's evidence. But my lords, I go back to my previous point. The only real inconsistencies put, my lords, this is where I have the references. The only real inconsistencies put in cross-examination were that at the first trial, as I've said, Campbell said Stubbs was at position number 35, not at number 5, but also it was a totally unfair point, in fact, when you look at the evidence. But never mind about that. And the other point is that he was cross-examined on was that at the preliminary inquiry, Campbell had picked out Evans as Dye and Dye as Evans. And so the argument went, Campbell obviously didn't know what he was talking about. Those were the 2 points on which there was cross-examination. But in my submission, if you look at how the judge dealt with it, if you go to page 596, lines 16 to 32, there was nothing wrong in the way he dealt with the matter. And it's 596, 16 to 32. You'll see the judge here points out, I think, one of the lines of cross-examination, and from line 16 onwards. And then he also mentions a point about Campbell having eye surgery and so forth. And then after that, he describes at some length Inspector Mackenzie's evidence. My lords, it's true, of course, the judge doesn't mention that Campbell had given inconsistent evidence about the parade at the second trial, but as I've said, no surprises there because no one made any point about that. So, my lords, that's what I say about the summing up. I say it was a perfectly adequate summing up, bearing in mind the issues in the case and the evidence before the jury. My lord.
Yes.
Yes, so just one question. If the jury were to reject Campbell's evidence in relation to the ID parade, should the judge have said something about the dock identification, which it would then become, or may become?
If you reject Campbell's evidence as to the identification, as to the identification grade, they would necessarily be rejecting the evidence that he'd picked out Stubbs, and that all that would be left with would be the rest of his evidence. In my submission, there wouldn't have been any need for him to go any further than that, which was implicit in his directions anyway. If you accept Mackenzie, you must fundamentally inconsistent. If you accept Mackenzie, you must reject Campbell on that point. My lords, I submit one must. I mean, jurors one must give some, what you might call, common sense and intelligence to jurors. They would realise perfectly well what it meant to reject, or rather to prefer Mackenzie's evidence to Campbell's evidence about what took place at the parade. They wouldn't need to be told, and then you must reject Mr. Campbell's evidence if you accept Mr. Mackenzie's evidence. The only question, my lords, I just speaking hypothetically, one might say, well, should that have some impact on how they treat his evidence of recognition, generally, which in my submission would be no, there's no need for a direction on that, because it wasn't specifically challenged, qua recognition evidence.
Yes.
My lords, I think that deals with Campbell and the question of whether to admit his evidence and the parade. My lords, that brings me to Scott. And in my submission, the most important thing with Scott, it's not necessarily the most interesting thing, but one does have to understand how the case was put to the judge in relation to Scott. And my lords, I've got 10 minutes left. Perhaps I can just deal briefly with how the case was put to the judge on whether or not Scott's deposition and evidence at the first trial should be put in. My lords, before the voir dire, in relation to Scott took place, Mr. Ducil, on behalf of Mr. Stubbs, on the 19th of June, objected generally to the admission of Scott's evidence, but one of the bases on which he objected to it was that it contained a doc identification. My lords, if I can just ask you to look at the references, it's bundle 1 and page 100. And one can pick it up at line 29 in page 100. Perhaps one can pick it up at line 22. This is Mr. Ducil addressing the court. What I'm saying is this: before this can be done as part of the process to admit the reading of the deposition, these circumstances do exist that you ought to exercise your discretion of not allowing the depositions to be read under 178. And because as far as we're concerned right now, it has to be 178, and so the Lordship has already ruled that it is admissible. The only provision that can become relevant is 178. So what I'm saying, my Lord, is given all the circumstances, factual though they may be, these are matters bearing in mind for all intents and purposes, whatever identification that's going to be given in this case is going to be doc identification. So this is really what you might call, right at the outset, then the judge says, I know what the evidence is going to be. Ducil, I'm merely preempting that this will be a doc identification. There are certain things which would arise and so on. What's the difficulty in dealing with it at the end of the prosecution's case? It's part of the evidence. Difficulty, my Lord, is that before it can be admitted, your Lordship has to exercise your discretion to admit it. In relation to the conditions provided in the statute, in other words, that the man is dead, then Mr. Ducil goes on to say it's a little more than that, and he goes on to argue about the statute, and then one can pick it up again at page 103, line 6, and he then goes on from line 6 on 103 to line 7 on 104 to make further arguments as to why he says this is doc identification and there should therefore be, the statement shouldn't be allowed in. And then the voir dire proper takes place at page 150. Now, my lords, I don't ask you to read all the arguments that took place at the voir dire. Can I just ask you to turn to our written case, which is at 3824 in the record. Paragraph 36. And these are the reasons which are put forward actually at the voir dire by Mr. Ducil, and you can see I summarised them 36.1, we summarised them 1, 2, and 3. But curiously enough, he doesn't actually advert to the doc identification point at this time. He takes other points about the unreliability, contradictions, and so on and so forth. Now, one then turns to how the judge dealt with it. And for that, my lords, I submit it's important to go to the record again at page 171. This is his ruling on the voir dire, 171. Begins line 15. And you can see the judge recites the various arguments. Line 15. And he recites Mr. Ducil's arguments. And then he goes to his rule. One then goes to page 173. And this, my lords, is terribly important. Well, perhaps I should take it to 172. 172, line 28. The director referred me to the case of Scott, applying the common law power to ensure fair trial, in which there was one eyewitness who was dead, and the sole issue is identification. And he says, in the light of the authorities are satisfied that the discretion of a judge to ensure a fair trial. And so the judge obviously reads out quite a chunk from Scott, which, my lords, we've again recited in extenso in our written case. It's only when the judge decides that such directions cannot ensure a fair trial that the discretion should be exercised by the exclusion of the deposition. And then, very significantly, my lords, the accused Stubbs and Davis were identified by doc identification. He's talking about Scott at this point. Unless the witness has provided the police with a complete identification by name and description, an identification parade should be held. I accept that in-court eyewitness identification evidence called doc identification should generally not be allowed. It lacks probative value and is highly prejudicial. While Lord Hoffman, in delivering the decision of the board, and he's talking about Goldson here, made it clear that an identification should normally be held, the principle in case of disputed identification, there ought to be an identification parade. So he turns his attention to Goldson as well. Even if you're talking about disputed identification, there ought to be one. Lord Hoffman also made the point that it was good practice for the police to have held the parade unless it was clear there was no point in doing so. This would be the case if it was accepted and capable of serious dispute. Then he continues, from reading the transcripts of the deposition, the deceased Stubbs, before the incident, there are, however, discrepancies in his evidence and the deposition and so forth. He talks about the discrepancies, and he then goes on to mention various other points, but the conclusion, I think, my lords, if I may just check my notes, is at lines 16, I think, line 16 on 174. So in my judgment, the evidence of identification in this deposition and transcript of witnesses are not of such poor quality that would have an adverse effect on the fairness of the trial. It can be put before the jury. In my submission, the judge has taken into account all the relevant factors, including the fact that this it could be regarded as a doc identification, or indeed is a doc identification. He says, I'm going to admit it anyway. So, my lords, this isn't a case of the judge exercising discretion without reference to relevant considerations. He's exercised it by reference to relevant considerations. And my lords, I've lost the precise reference, but I'm sure somewhere he says one of the points is that there's other evidence in the case as well. And that, of course, is important. And so if one says, was the judge bound to exclude Scott's evidence because it contained doc identification? The answer is no, not necessarily. Next question is, did the judge consider the point? Yes, he did consider the point. So I say, where's he gone wrong? Not at all. It's a reasoned decision by reference to the right principles. If I may, on Monday, I'll dig up the reference where I'm fairly sure somewhere the judge says there's other evidence in the case as well. Oh, my lords, that's right. It's 174, lines 7 to 15. As for the directors,
which line?
7 to 15, page 174.
Thank you very much.
As for the director's argument, that's a jury matter. The quality of the evidence in deposition and transcript of identification evidence in relation to Davis and Stubbs cannot be used unsupported. It has to have some support of other witnesses who gave evidence before. So that's his reasoning. So I know it's a doc identification, but I'm going to admit it because there's other evidence in the case. That's a perfectly sensible, if I may say, approach.
Yes. Well, that seems to have taken us up to 4 o'clock, Mr. Knox. Is this a convenient time?
Yeah, it's a convenient time for me, yes.
Yes, good. Right, we'll reassemble on Monday at 11 o'clock. Thank you all very much. Thank you.
Thank you, my lord. Thank you.